Welcome to the Explainer. Okay, let's talk about a really common estate planning move. One that seems totally smart, but could end up costing your family a fortune. To make things simple when you pass away, you think, hey, I'll just add my kid's name to the title of my house. It feels like a responsible, forward-thinking move. But what if that one simple act was actually a ticking time bomb, setting them up for a huge, unexpected tax bill down the road? As you're about to see, the entire outcome hangs on one critical and honestly often overlooked detail. So here's our game plan. We'll start with a classic story, then get to the absolute heart of the matter, the one question that changes everything. After that, we're going to follow two totally different paths to see just how wild the difference in the final tax bill can be. And then we'll wrap it up with the key takeaway you really can't afford to miss. All right, let's dive in with a real-world situation. We'll just call it the story of Mr. A and Mr. B. Okay, so here's the setup. You've got a parent, Mr. A, who owns his home outright. To simplify his estate, he puts his adult son, Mr. B, on the title with him as a joint tenant. Now, the whole time, Mr. A keeps living in the house. It's still his home. And his son, Mr. B, he lives somewhere else completely. He has no plans to ever move in. Seems simple enough, right? And here we are. This is the absolute core of this entire explainer. Because every single tax dollar we're about to talk about depends on what the word ownership actually means, especially in the eyes of the taxman. And this is the magic term, beneficial ownership. You got to think of it like this. Legal ownership, that's just whose name is on the piece of paper. Beneficial ownership is about who's really in charge, who lives there, who pays the bills, who reaps the rewards, and who carries the risks. And let me tell you, the Canada Revenue Agency cares a whole lot more about who's the beneficial owner than whose name is on the deed. This really lays it out perfectly. Legal ownership is the paperwork. It's easy to see. But beneficial ownership? Well, that's who the CRA says is the real owner for tax purposes. And here's the kicker. If beneficial ownership changes, the CRA calls that a disposition, basically a sale, even if $0 changed hands. And that right there is what triggers a tax event. So let's go down our first path, Path A. This is what happens if Mr. A's intention was to give his son a true gift. I mean, he didn't just add his name to the paper. He actually gave him half of the true ownership, the beneficial ownership. The second Mr. A does this, from a tax perspective, it's as if he sold half his house. Boom. Now, Mr. A can probably use his principal residence exemption and pay no tax, which is great for him. But here's where that hidden trap starts to get set. For his son, Mr. B, the tax clock on that 50% share starts ticking that very day. His cost is now locked in. Okay, so let's fast forward. When Mr. A passes away, his other 50% of the house is considered sold at whatever its value is on that day. Mr. B inherits that second half. So think about what Mr. B's total cost for the property is now. It's this messy blend. Half of it is based on the value from years ago when the gift happened, and the other half is based on the value at the time of his father's death. Now, let's look at the flip side. Path B. What if the whole thing was just for convenience? What if Mr. B's name was put on the title, but the understanding was that Mr. A was always the true 100% beneficial owner? In this scenario, when Mr. A adds his son's name to the title, the immediate tax impact is nothing. Zilch. A big fat zero. Why? Because beneficial ownership never actually changed hands. As far as the taxman is concerned, no sale happened. Mr. A still owns 100% of his house. And this is so important. When Mr. A passes away, he's then deemed to have sold the entire property, 100% of it, at its fair market value on that day. Mr. B inherits the whole thing, and his cost is set at that full up-to-date value. There's no blend, no complicated math, just one clean, simple number. Okay, this is it. This is the moment of truth. Years have passed. Mr. B now owns the house, and he decides to sell it. Let's put these two paths side by side and see what happens when the tax bill finally comes due. Just look at the difference here. In Path A, the true gift path, Mr. B's cost is that messy blend. This means he's on the hook for capital gains tax on all the appreciation on that first 50%. For all those years his dad was still alive. But look at Path B. The cost is simple. It's the value at death. So Mr. B only pays tax on the growth after he inherited it. The bottom line is pretty clear. Path A can lead to a way higher tax bill for the son. And if you need to see it in black and white, here it is. This is the exact wording from the CRA document. It's the smoking gun. It confirms that in that true gift scenario, the son's taxable gain has to include the growth on his first 50% slice right from the day he got it. That, my friends, is the hidden tax trap in all its glory. So, after all that, what is the one big thing you absolutely need to walk away with? Let's boil this entire thing down to its essentials. At the end of the day, it all comes down to your original intent. Was this a genuine gift, or was it just an arrangement for convenience? As we've seen, one path can saddle your child with a massive future tax bill, while the other can save them a small fortune. And you have to know, the CRA will look at all the facts to figure out what you really meant, so being crystal clear from day one is everything. So I'll leave you with this question to think about. If you've already added a child to your property's title, is your intention documented and perfectly clear? And if you're thinking about doing it, which path are you actually choosing? Because, as we've just laid out, the answer has some serious financial consequences. Getting professional advice to make sure your plan works exactly the way you want it to isn't just a good idea, it's absolutely essential.